Today's the mandatory lectures for Florida, Pennsylvania, for medical errors and HIPAA and some other laws and things of that nature. So we're hopefully we'll be out by 12:30 or 1. I did develop some laryngitis coming up from Florida, so I have to slow down, which is not the way I usually work. So we're going to start with Nan Gallagher. She's our General Counsel for NJOBS. She's also a specialist in HIPAA and medical legal advice. And she's going to start us off today. So, Nan Gallagher.
Good morning. Wake up, everybody. We're going to talk about a scintillating topic today. No, I do want to thank you all for coming. I know it's early. It certainly is for me. My name is Nan Gallagher. I am the owner of the Nan Gallagher Law Group. We have offices in Morristown and New York City, and we're proud to serve for the last several years as General Counsel to the New Jersey Association of Osteopathic Physicians and Surgeons. It's a pleasure to be here. I know that we started a little bit behind the scheduled time to accommodate everyone streaming in and having breakfast, so I am going to get this course over with on the same time, which is 8:30. This is normally a 2-hour presentation. Be happy you're not sitting through that. There's a few topics in a healthcare lawyer's life that she really can't make sound very exciting. One is HIPAA, and another one is end-of-life care or POLST. So you're going to sit through the HIPAA one. And we have a federal requirement that you must undergo this training every year. Federal law says that every licensed healthcare practitioner must undergo HIPAA training annually, as well as your staff. So you can consider this your annual HIPAA training. And I will skip through a bunch of slides, so we're going to skip over a lot of stuff that's going to make your eyes glaze over. But what you will be able to walk away from this presentation is, what do I need to know about HIPAA so I don't make a big mistake and I don't have to call Nan Gallagher? But if you do have to call me, give me a call. I can help walk you through it. Okay. I have no conflicts or financial interests here. And a special thank you to NJOBS and TIMA for having me. If anyone's interested in learning about my background, this is all I do. I represent doctors. I have for over 20 years. Represent a bunch of associations and medical staffs. I am a certified HIPAA administrator. I'm also a certified OSHA analyst. So I help with office compliance, and if you do get into some trouble with any of these daunting federal requirements, you can always give me a buzz and I'll walk you through it. So you'll see as I go through this, it's generally my style not to just read from the slides. I think that increases the likelihood that you will be snoozing at your table. But we will talk about broad strokes here for HIPAA, and I'm sure all of you understand. But there are some things that people don't understand or have misimpressions about. HIPAA generally is broken into two parts, privacy and security. The security component was a supplement to the original HIPAA statute. The original HIPAA statute, which is a federal law, came into effect in 1996. There have been subsequent modifications of the statute over time, with most notably in 2017. So while we are going to go through some of the HIPAA requirements, I do want you to understand that as you get to the point of having documentation for your practice so you do comply, give some thought to the fact that if any of your HIPAA materials were prepared pre-2017, they likely need to just be reviewed and dusted off. I can certainly do that for you. I don't charge to give you an opinion if you have outdated materials. So in a nutshell, privacy law under HIPAA, which there's a federal law, and then New Jersey, Pennsylvania, and New York, as well as many other states, have their own local HIPAA regulations. The regulations in New Jersey, where we're situated right now, are a little bit more unique and stringent. than the federal requirements, but if you're adhering to federal requirements for privacy or for security under HIPAA, you're going to be fine. In a nutshell, though, if you are a physician and in any way you're dealing with electronic protected health information, EPHI, you may hear me call it PHI or EPHI, electronic protected health information, you are subject to HIPAA. So if you have paper charts in your office, you don't have to necessarily comply with HIPAA. You should. If you're only strictly paper charts, you should comply with HIPAA, in my opinion, because the overarching theme for today is that patients don't understand what HIPAA is. They think they do. They'll say to you, oh, that's a violation of my HIPAA rights. 9 times out of 10, you have not violated someone's HIPAA rights. They hear a little bit about it on Law and Order or Grey's Anatomy, and they think they know what HIPAA is. So I get frequent calls from doctors and frequent calls from patients who I don't represent. They will come to me and say, well, was this a HIPAA violation? And I say, no, it was not. We're going to talk about over the course of the next 40 minutes or so what is actually a violation versus just an unintended disclosure for HIPAA. If you have an unintended HIPAA disclosure, meaning you didn't intend it, it wasn't a breach, it was just kind of, probably shouldn't have faxed these records to that unsecure fax, etc. That's an unintended HIPAA disclosure, and it's not going to bring you huge penalties. It's not going to bring you ill repute. So we'll talk about that as this course goes on. But ultimately, under the privacy statute for HIPAA, it's very important that you have standards and formats in the form of a policy manual, both for privacy and, as we'll get to it, for security for your practice. So if you have a private practice, or you are an employee of a private practice, and you deal with EPHI, or your administration deals with EPHI if you have an EMR, you must have and be somewhat familiar with, note my rolling eyes when I say that, somewhat familiar with what the two manuals, the privacy policy manual and the security policy manual say. So if you have no idea, you should probably get yourself some policy manuals or ask someone who you work for, because that is a major requirement for your compliance, as well as this training. Under the security segment or silo of HIPAA, it again applies to EPHI, there are standards for security in your computer systems, your servers, your networks, password protection, all of the data encryption that you are required to do under that statute, that all falls under the security heading. So think of privacy as the ethereal obligation to keep a patient's protected health information private and to transmit it securely. And then under the security section, make sure that you think about having good computers, good servers, good networks, good encryption methods, good softwares, great password protection, great usernames, changed passwords, limited access to the EMR, not letting patients see your EMR. That's a big one. We'll talk about that. And then that's how really you will end up achieving full compliance. High tech, just to bore you a little bit further, high tech is a segment, it's a different statute, it's a segment or an offshoot of HIPAA, it's federal law, and it essentially governs health information technology. And that really is an add-on to the security rule under HIPAA. So it requires that you have to notify of large breaches. Usually you see that, or maybe you read that in the realm of Horizon, a laptop was stolen, there was a huge breach. Then that requires added measures by the healthcare entity or business associate, which we'll talk about in a moment, to notify individuals of breaches. It also has increased penalties for violations, and then it also requires notification different formats to notify individuals that their health information may have been breached. I remember a few years ago, I was an insured of Horizon, and I got a notification that my protected health information might have been breached because a laptop had been stolen by an underling at Horizon. And I was very upset, and they offered to provide 1 year of identity protection for me, which certainly didn't comfort me or the thousands and thousands and thousands of other insureds, but it was the best that they could do and that they were required to do in terms of patient notification under the HIPAA statute. They also Horizon did have to pay a lot of money in fines to the federal government. Federal government wants, believe it or not, this is my theory, they want HIPAA violations. They want breaches because they make money. They make money on these fines. So when there is a complaint that comes in to the U.S. Office of Civil Rights or the New Jersey Office of Civil Rights, for example, these are agencies that govern HIPAA and enforce HIPAA. They start to salivate because they're going to make a lot of money if it's a real, true breach. As far as business associates are concerned, which was really something that developed under the high-tech component of HIPAA, business associates are those entities, vendors, etc., with whom a physician deals. So maybe it's your EMR company, maybe it's your biller, maybe it's your accountant. Some accountants actually have occasion to review patient health information when they're making determinations and giving opinions to doctors on out-of-network fees and how to bill them and financial guidance. I would also tell you that even the relationship between an association and a doctor should have a business associate agreement in place. So you need a business associate agreement in place with any vendors or associations with whom you are exchanging health information with, or they're exchanging it to you. So I do represent several societies and associations of doctors as their general counsel, and I can tell you it happens all the time where I, as the attorney, will get an email from an executive director saying, can you help Dr. Smith with this? He doesn't know if he needs to appeal this. And it's simply sent by unencrypted email, and it's PHI, and it's sent to my email, which mine is secure. I don't know, I can't speak for the associations. But the doctor initiated sending that material from his AOL account or his Hotmail. So I think we're all smart enough in the room to know Gmail, Hotmail, AOL, all of those newfangled free email services, they're all unsecure, and most doctors use them. So just be careful and mindful and vigilant that if you are sending any patient information, and that's going to include names, demographics, social security numbers, and it can just include the name. That's a question I get frequently. Well, what if it's just the patient's name? That is HIPAA protected. That's a HIPAA protected detail of information. So ultimately, if you are sending protected health information to anyone, of a business associate, or frankly to anyone, if you're sending it to me, we're going to have a business associate agreement in place. If you're going to send it to your association, the same. So high tech is the component of the HIPAA statute that enforces doctors sending and receiving PHI properly. So there are different ways, and I won't waste your time this morning, about how you can send and receive protected health information properly, whether it's using secure faxes or in share file type of things or encrypted email. I won't sit here and bore you with that, but if you want some information or guidance on it, you can certainly feel free to call me. That is the most heavily scrutinized way that the Office of Civil Rights, with both the federal government and New Jersey, will come after a doctor if they see that he or she is sending ePHI improperly. So there are different branches towards HIPAA enforcement. I don't think it's a good way to start any Saturday with just scaring doctors about what they need to worry about. But in my slides, which I believe you can all receive copies of, you'll see the different ways that the government will go about enforcing. Most notably for you is the offices of civil rights. They will send a letter or knock on the door, but it's more often than not a letter which says we are in receipt of a complaint. So the complaint will say something like, patient believes that you improperly or carelessly sent their protected health information from one way to another. And also CMS. CMS will be notified if it's a Medicare patient if there's been some type of improper transmittal of protected health information. I did want to just tell you one little side story, interesting story, but it's so funny how security and privacy can become compromised. So a few years ago, I represented a doctor, and he called me and he said, "You're never going to believe this. I have a problem. A few months back, I hired a shredding company to come take my old files that were older than 7 years and to shred them." And I said, "Did you use a HIPAA-compliant shredding company?" Which you should do. And he said, "Yes. Yep, they came, big truck. They took years and years and years and years of paper charts, and they took them away." And I said, "Okay, good for you. What's your problem?" And he said, "You're never going to believe this. I got a phone call yesterday, months after the pickup, from a woman 60 miles from my office who said that she found one of my charts, my paper charts, on the side of the road, kind of crumpled up next to the curb." And I was like, oh my goodness, what? So this was, I will call her a conscientious good citizen. I would do that if I saw a patient record or protected health information on the side of the road. But she called and she was angry. This was not the patient. This was a woman 60 miles from the doctor's office. And she said, "How dare you carelessly discard or take care of your patient charts? I don't know who this patient is, but I'm calling her. I already have calls out to her, and your license should be taken." Remember what I said a few minutes ago? Every patient thinks they understand HIPAA. Well, first of all, it was not a HIPAA breach. It wasn't even an unlawful or unintended HIPAA disclosure. Why? Because it was a paper chart. Okay? Now, in theory, we shouldn't care. In theory, that because it was a paper chart versus EPHI, it shouldn't matter to us. We're going to safeguard protected health information. But if you read the HIPAA statute and you look at the enforcement regulations, paper charts doesn't really matter as far as enforcement. They care about EPHI. But let's hold that aside. Doctor had done everything he could do to properly handle this. He hired a HIPAA secure vendor, and they came and they just carelessly, something must have bounced out of the back of the truck, which is what he was told. Patient was notified by this conscientious good citizen, and the patient was very upset, and she wrote a letter. She was a Medicare patient. She wrote a letter to the New Jersey Office of Civil Rights and to CMS. And that doctor had to spend a year of his life answering for the mistake or carelessness of a shredding company, right? So you can't control the universe. You can't control that a shredding company is going to have hit a pothole and something's going to bounce out of the back. That's not the takeaway here. The takeaway is he probably should have had a HIPAA business associate agreement in place with that vendor that advertised itself as HIPAA secure. So let's just be clear on this point. You're only obligated to keep patient records for 7 years unless the patient is a minor. Then it's essentially 2 years after they reach the age of majority in which you have to keep those records. But if you are purging, and I recommend that you purge paper charts. I'm all in support of that. Maybe it's my type A or my OCD. But why would you keep a chart around if you're no longer seeing that patient, more than 7 years had passed, they're not a minor, and it's just an opportunity for something bad to happen? So if you are purging records, which I do think you should, find a HIPAA compliant shredding company and make sure that you vet that. Not just, oh, well, it was on their flyer. Ask them questions about what they do. Make a list. Keep an inventory of the patient charts you gave. Yes? Yes, the question was, I'm not going to make you get up, Dr. DeSantis, but I know the handsome gentleman to the side had said, if anyone has a question, feel free to come to the microphone, but we're doing good. So the age of majority. So in New Jersey, the age of majority is considered 18, which means that you should keep records for 2 years past that, which is if the patient was a minor, keep the records until they're 20. However, there is case law in New Jersey, and it's inconsistent with what I just told you. And there's the appellate division of all different divisions have differing opinions on that. There are some courts in New Jersey that say you should keep the records till the patient is 2 years past the age of 21, which would mean keep the patient records till they're 23. I say the law doesn't say that. You know, I was watching Yellowstone. I don't know if is anyone a Yellowstone fan here? All right, good. I was watching Yellowstone. I was binge watching it a few weeks back, and someone on the show said, you got to be careful for lawyers because they know exactly how to break the law. But in all honesty, I know that the law says it's 2 years after 18 in New Jersey. But because there is differing opinion among the appellate divisions in New Jersey, some of which say it's 2 years past 21, if you want to be secure and conservative, wait till the patient's 23rd birthday if they were a minor and get rid of it. As far as, yes? Well, CMS on some plans requires 10 years. So the question was, I know we were saying it's 7 years, CMS requires 10 years. Some CMS plans require 10 years. The look-back period for fraud for patient record retention is 10 years. It's 10 years in this state for any payer or any patient. If there's a fraud investigation, the statute of limitations is 10 years. So we should always be careful if they're a CMS patient. Technically, New Jersey state law, which trumps the federal law, says 7 years. But if you are credentialed with CMS and are a member of a bunch of their different plans, my advice is keep them for 10 if they're CMS patients. You don't have to. If CMS comes after you on year 8.5 and says, we want our records and you were supposed to keep these, give me a call, because I would fight that to the high heavens, show them the New Jersey regulation, and say, unless you're snooping around for fraud, have a nice day. But anyway, so you're learning more about my personality as we go on. Yes, doctor?
Just to close out shredding,
Yeah.
big companies will bring a shredder truck and shred on site, and that way they need a bale of hay. They don't need with any physical information or charts. That would potentially eliminate that problem if you hire a company that shreds at your site.
Well, the doctor pointed out having a vendor, a shredding company come and shred on your site and go away with shreds and hay. That's a great idea. You should come up here. Let's lecture together. Although I want to wear a sweatshirt when I lecture. This is the best you get from me, fashion-wise, on a Saturday morning. But that's a great idea. What I do in my firm, because all we deal with is PHI, we have a shredding box, right? So one of those DocuVault thingies, and we put all the records in there. But I don't deal with as many records as you deal with, but I deal with a lot of records. And we just put everything in the box. The HIPAA secure company comes with some level of regularity that one of my underlings knows about. And then they shred it, and we get a certificate, and that's great. But I like when they shred on site, so you don't have patient records on the side of the road. Just as the footnote to that story, that doctor whose record, unbeknownst to him, ended up on the side of the road, he spent a year of his life trying to fight and he won. I mean, ultimately, it wasn't his responsibility. He did have, although it was non-compliant, he did have a business associate agreement in place with this HIPAA secure company vendor that came to take the records, but the patient was still upset, and that patient did a lot of damage. That patient called the state board. She called CMS. She wrote bad online reviews. So in some respects, the damage was done already. Now, I won't go through here for you all the violations that could happen, but I did want to point out a couple things. There are intentional disclosures. Those are big intentional breaches. I don't think that happens very much. And then there's unintentional or accidental disclosures of PHI. That's this second part here is where most of the, quote, accidents happen. And accidents do happen. But an unintended or an unintentional accidental disclosure of protected health information, that does not necessarily mean a breach. Can I give you another example? I'm an example person, because otherwise you're going to sit here and say, well, oh my gosh, like this was incredibly boring. So we represent an orthopedic practice. The doctors, there's 5 orthopedists, and the doctors have essentially something that looks like a kiosk, like this, in their office, and it's a station where they can dictate in their whatever Dragon or whatever their EMR is. But they sit there and they have their little handheld dictaphone, and they say, you know, patient John Smith was in today for this and that, and they do their quick dictation. So I am also a patient of that practice. I have heard them dictating at their dictation stand. I don't care, but I've heard it. And it's quiet, and it's quick. Well, another patient had complained. Another patient complained to the practice, complained to the State Board of Medical Examiners, complained to the Office of Civil Rights that this was a huge HIPAA breach because I'm a patient of the practice and I hear that this doctor is saying patient had this and that and this and that. Remember what I said earlier? Patients think they understand HIPAA, but they don't really understand HIPAA. So I had to do a full defense of this practice's the allegation against this practice for the Office of Civil Rights. I had to say to them, nothing is wrong here. There were no patient identifiers dictated in the verbal dictation. And I don't know at the time, this was every bit of 6 or 7 years ago. I don't know what software they were using, but at the time, everything, according to the doctors, was auto-populated in the EMR. They don't have to say it's patient Marjorie Jones. They just call up the patient's name, click, 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 get to the findings or progress notes section or orders, whatever section this doctor was in on that day, and he dictates. You know, patient was in, and dictation. And then it got shipped off. I was told it got shipped off to another country and transcribed overnight and then put into their EMR. So ultimately, the net result of that huge burdensome investigation, and it was an expensive one for the practice because fines were levied originally against the practice. They shoot first sometimes and ask questions later, some of these agencies. So the net result of it was there was no harm, no foul. There was no HIPAA breach. The practice was given a letter of collegiality. It wasn't even a warning letter saying, maybe don't do your dictation in earshot of patient rooms, or make sure patient rooms the doors are closed, etc. And you know what? The doctors were on their way, but boy, they were angry. They were angry. They spent money. They paid some fines. Some of the money they got back, they had to pay for an attorney, and which wasn't that expensive. It wasn't that expensive, but they had to outlay this money. And at the end of the day, they didn't do anything wrong, but it took a year of their lives. So patients think, well, if I hear something about another patient, whether it's their name or not, it's a HIPAA breach. Well, no, it's not a HIPAA breach. Maybe it was an unintentional disclosure of PHI, and I'm not even going that far, because I didn't hear anything in what I was told in this woman's affidavit that triggered any protected health information for me. So there's various tiers of penalties, and they can range anywhere from $250 to $50,000. And then now with Tier 4, which is the more recent modification of the HIPAA statute, there's a maximum fine of $1.5 million, and that's really for any violations that are of such an egregious and intentional nature that they should have never happened in the first place. So we've already talked about PHI. What you should do if there was some unauthorized disclosure of PHI. If you feel, and it happens, I get this call a lot, if you feel that you have had an unintended or something coming out of your office, went to the wrong person, should have been handled better, then first thing you should do when you become aware of it is to minimize, right? Contain the fire. Contain it from causing any further problems for your practice. So immediately notify your HIPAA compliance officer, which, and pardon me while I leave the stage for a minute, I just want to get my water. But your office has certain requirements in terms of HIPAA compliance with regard to paperwork. You need that privacy manual. You need the security manual. You also need to have HIPAA compliant forms, things like authorizations for release of protected health information, things like having proper business associate agreements, also having things like HIPAA compliance officers, etc. So you should appoint, and it may be you, a HIPAA compliance officer for your practice. I serve as a HIPAA compliance officer for a lot of practices. That is something I don't charge for, but do you really want to know all the intricacies of this stuff? Some people just say, can I appoint you? And I say, sure, thank you. I'll take it. So the HIPAA compliance officer should be notified, as well as filling out some type of incident report. It can even be an email to yourself. On this date, Maggie sent lab results to the wrong doctor's office. That's not a breach. It was just an unintended HIPAA disclosure. There won't be a fine, but you should do something. Worst thing any doctor or doctor's office can do, even if there's a low-level, unintended, or accidental disclosure, the worst thing a doctor can do is nothing. So this happens a lot where lab results or radiology results go to the wrong office or for the wrong patient. Maybe your office has two Margaret Joneses as patients and the wrong records went to the right office. If something like that happens, don't do, oh no, I didn't hear this, it didn't happen, I'm not gonna do anything and we'll see if I get in any trouble. That is bad, because if you find out about it and do nothing, even if it's an unintended, very simple disclosure, that's where fines come in, because it then suddenly becomes like you're an accessory after the fact. You intended to hide this or conceal it, it's deceptive. So contacting maybe yourself, you might be your HIPAA officer, making sure they're aware, making sure that there's an incident report, even if it's an email to yourself in the office, making sure that if there's any containment that has to happen, if it's a small violation, if it's a big violation, the bigger violations, which you can see in these slides, which I won't bore you with, some of them have to be reported to the Department of Health and Human Services. Those are the big breaches, like the Horizon breach I told you about earlier. And then for those large security breaches like we're talking about that involve more than 500 individuals, you actually must do a publication with a prominent media outlet. So let's hope that never happens. We talked about business associates, so I will skip over that. But in terms of having a complete HIPAA documentation package for yourself, you should have a privacy manual, a security manual, business associate agreements, compliant authorizations for release of protected health information. You should also have a notice of privacy practices. If you're going to take one thing out of this presentation this morning, here it is. Are you ready for it? It's not on the screen. I can feel the suspension. I could just feel, it's electrifying. Are you ready, folks? Woo! All right, here it is. If you do not have a HIPAA notice of privacy practices, if you don't have it, you must have it. Let me keep going. If you don't have one that was prepared post 2017, you need a new one. Yours is outdated and illegal. If you need a new one, call me or email me. My information's at the end. You need one post 2017. And here it is, folks. Wait for the buildup. If you have a practice website, it must be on your practice website. And as unexciting as that sounds, that is the number one way you will get investigated in random investigations by the Office of Civil Rights in New Jersey. If you have a website and you don't have your notice of privacy practices on it, usually I see it in like the patient forms section. Download our forms or click here for our forms. That's where I usually see it, and that's fine. But if you have a website and you don't have your HIPAA notice of privacy practices prepared post 2017 on your website, you are waiting to get investigated. A little knock at the door or a letter by the Office of Civil Rights. That's how it happens. They've told us. So especially as we move through this pandemic, the Office of Civil Rights has been doing more and more of these audits. Do you have notice of privacy practices? Is it current? Do you have signed acknowledgments from all patients that they have reviewed your notice of privacy practices? Are those current? So if you do need a new one, and you're going to reach out to me, I'm going to answer a question for you ahead of time, which is your patients need to acknowledge, they need to re-acknowledge that they have had access or opportunity to review your notice of privacy practices. And then also, in terms of acknowledgement, those patients, they don't have to go to your website. It should be there if you have one. It can be posted in your waiting room. It could be with your forms in the front with a clipboard, please sign here. But every patient should be re-acknowledging that they have reviewed your 2017 or more current notice of privacy practices. I'm just jumping all over the place, though. I apologize because you're probably like, she's not even reading what's on her slides, which I don't know about you. Do you want to read this stuff? Anybody? Anybody? In the back. All right. So let's talk about passwords real quick. As I told you, I'm going to get you out of here on time. How many of you, by a show of hands, have at least one office staff person working for you? Okay, thought so. So you have staff people working for you, and I'm assuming many of you have access to EMR. If you have electronic medical records, each individual who works in your practice must have his or her own username and his or her own regularly changing password. Reasonable, seems pretty common sense, but I can tell you those passwords need to be changed. They need to be chosen by the individual user. So if you're setting someone up and their password is, hashtag, exclamation point, 123, that's their original password you gave them, they must change it. And there must be a setting in place or a reminder in your calendars to reset those with reasonable regularity. I say usually every 2 months is fine for me. Many of these programs will auto remind you, but 2 months is reasonable when you're a doctor's office. I don't have to change my passwords every 2 months. I change them every 4 months. So if you're going to come hack me, I just change my passwords. So don't come knocking. As far as, let's talk about, and I don't think it's on this slide. Let's talk about patients seeing your EMR. How many of you have examination rooms where the computer is in the patient room and you're typing away when the patient is there? Anyone? Okay. I'm a patient. I go to these offices and I, with reckless abandon, give my unsolicited advice. And I love doing it. And I say, oh, can't do that. Can't do that. How many times have I walked into, well, I don't know, a pediatrician's office, my general practitioner's office, whomever, and former doctor's offices, where there's a screen, and whether maybe I'm getting a radiology study and there's a list of patient names, all of the people who were set to have these radiology studies, or all the people who, maybe it's the screen from the patient who was in the room last at a cardiologist. That is risky behavior. There should be some type of method to minimize or black screen or to obscure. There's a lot of screen protectors that can be put in place on different computers that can obscure the view of someone looking, but not the person who's typing. The person can see it, but if someone's looking from a side, they can't see it. These are measures that HIPAA expects you to follow. The federal law says that you should have measures in place that deal with obscuring another patient's access to other patient names. So that's very important. That's risky. That's, remember what I always say, patients think they understand HIPAA. They don't understand it. So if they walk into your office and they're like, why is there the former patient, I'm reading here, look at this, look at all this. This is a HIPAA breach. Well, it's not a breach. If that happens and you get a patient who's having a bad day and they get very aggressive with you and they say, well, what if that was my information? Why is that on the screen? First things first, feel free to give me a buzz. I get that call a lot. But even if you don't call me, notify your HIPAA officer, maybe it's you. And it's essentially damage control at that point. It wasn't a breach. We take this very seriously. Thank you for bringing this to our attention. This should have been minimized. I can assure you this was an isolated event, right? That's what we would do. So following those kind of PR steps should minimize the problem and neutralize it. Ultimately, though, for you, if it doesn't neutralize the problem and you get a call or a letter from the Office of Civil Rights or the state board, don't go that alone. Don't go that alone. The state board, which governs your license and has nothing to do with HIPAA, nothing to do with HIPAA, they can bootstrap liability to you if they think that you've broken some rules. They'll throw it into one of their catch-all regulations. They'll say, well, you should have known better. And we're going to say that you have professional misconduct for doing X, Y, and Z under this provision of the New Jersey state regulations. Let's not ever let it get to that. But don't go that alone, because what is really an easy explanation for some unlawful or unintended disclosures, if you give the wrong explanation, you're just inviting the spider to weave you into its web. So, we are almost at the end, and I don't think I've read off of a single one of my slides. But before I do, and I can answer questions, and I have a couple more things I want to tell you, but really this is the meat and potatoes of it. Ask yourself, do you have a credible compliance plan in place? So you just had HIPAA training for 2022. As I mentioned, so you get CME for these presentations at AROC, which is great. But also, if anyone wants a certificate from me, like I'm certified by HIPAA, I'll issue you one. It's not CME related though, but I'm happy to do that, so you can feel free to reach out. But do you comply with HIPAA? Are you following reasonable steps? Faxing is not governed by HIPAA. If you want to send patient records, hopefully ones that are not voluminous, from point A to point B, let's just say, for example, I'm here, and a client of mine, he says, well, I don't have a scanner at home. I need to get you these records. Can I fax them to the hotel? He can. I think that's crazy, and I think this loop in HIPAA is going to close, but he can fax some patient's records to the front desk at the Hard Rock and not violate HIPAA. I think that's incredibly poor practice to do that, but he can do it. So faxing is a way around HIPAA. I don't recommend it. Do you have your privacy manual, security manual, business associate agreements? Do you have authorizations for release of protected health information? Here is one point on that I want to tell you. How many people in this room have ever received a subpoena from a lawyer to release records? Okay, good. It happens all the time. I send subpoenas all the time. That subpoena must accompany a HIPAA-compliant authorization signed by the patient or the patient's executrix, administratrix, etc. Maybe the patient's deceased. A subpoena, even though it looks all formal, looks all legal, it's from a lawyer, ooh, I better comply with this, a little scary. If it doesn't have a signed authorization from the patient or the patient's guardian or executor, etc., you're not to comply with that. You can always feel free to send those over to our office. We handle those. We don't charge for that. Hey, Nan, we just got this subpoena in. Is it good to go? Can I comply with this? I take a look and I say, no, it's not. You want me to send a letter, doctor? Yes, please send a letter. Yes, question.
Distinction between, what you're saying is, I'm not an attorney, but that's what a subpoena duce et tecum versus when you get one actually from the court itself.
There is no distinction. So typically courts don't issue subpoenas directly from themselves. What happens is the court will approve a subpoena that an attorney submits for filing. So if I want to issue a subpoena, I have to have a court say, you can sign the clerk's name, etc. But it looks like it's from the court, but it's from the attorney. Very rarely, I can count on one hand in 20 years how many times a court issued a subpoena to a doctor's office, unless it's the workers' compensation court. That happens sometimes. But if there is a subpoena and it is coming from an attorney, you do not need to comply with it. I'm not saying ignore it. I'm saying ask them for a HIPAA-compliant authorization. But if it comes directly from a court, I'd have to see it. But my advice is, no, I wouldn't issue anything to a court without an authorization. But agencies are a different story. If you get a subpoena from the State Board of Medical Examiners or the DEA, or name some other agency, I'm actually non-caffeinated this morning. If you get an agency subpoena, that is an exception to HIPAA. You don't need an authorization to release those records. But ask yourself, if you don't know, you're not sure, ask someone who does. We're readily available to help you through that. Like I said, we don't charge for that. Sometimes it's a matter of just us looking, sending a letter, saying, nope, we need an authorization. And also, sometimes doctors receive letters, not subpoenas, letters from lawyers enclosing authorizations. And, hey, please release the records of this patient. Well, here's some questions. One, how old is that authorization? Because there's a time cap on them. They're really supposed to be for a year or during the pendency of a litigation. If it was from 4 years ago, you shouldn't be answering. You shouldn't be releasing records. You need a fresh one, fresh authorization. The authorization that came from the lawyer, the other question you would want to ask is, does it comply with HIPAA? HIPAA changed in 2005, 2009, 2013, and 2017, and it's due to change again next year. Did the authorization include specific subsets for transgender information, psychotherapy records, specific subsets for drug and alcohol use? Those are newer requirements. You must have a patient's explicit consent to release psychotherapy records, to release transgender information, even progress notes that allude to transgender information. If there's any drug and alcohol information in those records, you need specific line items and an authorization to consent. So I'm going to say this as I close, because I want Dr. Carr to run his train on time. Ultimately, your record, your compliance paperwork, if you haven't looked at it in a while, send it over. I'll tell you if you need, I'll kick the tires. I'll tell you if you need an update or not. Or talk to your trusted HIPAA company. Maybe use HIPAA Compliance Now, or I forget what they're called, HIPAA something now. And then there's different organizations who do it. Have them take a look. If it's outdated, if your HIPAA notice of privacy practices is not on your website, put it there. Have it drafted after 2017. If your authorizations that come in from lawyers don't seem compliant to you, or you're not sure, then always kick it back to them or kick it over to me. I'm happy to kick it back to them. You want to strive to achieve the utmost privacy for your patient records. They'll thank you later. Yes, doctor?
We're vigilant about looking for signed patient authorizations for analog stuff that come for most of benign reasons. Everybody
Yep.
needs a copy of the chart for some issue that you deal with every day. And we always check the chart. And sometimes we had an issue once where the signature didn't match, and we weren't going to send it, and there was an issue. Apparently the wife signed it or something. So, you always have to double check that. We're vigilant. But the problem that we have now with digital stuff is they'll have this line on there, digital signature on file.
Mm-hmm.
We ignore those. We always want analog signatures. Maybe you have a different opinion. Digital signature on file, anybody can write. What does that mean legally?
By the way, did everyone hear that? You need to come work with me. When you retire, please come work with me. I love it. But if you have anything that you receive that says digital signature on file, if you're getting an authorization that says that, or your office may have a digital signature of a patient from years back, that is not, I can't say it's not HIPAA compliant. It's certainly not good practice. A doctor's office, and that's why I remember when I started with annual training is actually required of you and your staff. A doctor's office should have annual training on this stuff, to be vigilant, to be good, gatekeepers. You're the gatekeeper, right? You have to look and say, wait, the signatures don't match. Or we have a psychiatrist, he's an osteopathic physician who represents us. He was getting called and schemed by a decedent's son. That decedent is embroiled in I'm going to call it an estate dispute. He wants his deceased mother, who was the patient, he wants her monies. And he wants to challenge her competency level when she changed her will and wrote him out of it. But that son called the doctor, the psychiatrist, and said, I want to see my mother's records. I'm the executor, send them over. And that doctor was about to do it, his staff, doctor and his staff. And then he thought better and said, let me just check. Let me check with my association, and they ended up kicking it over to me. And first of all, the son was not the executor. There was, it appears, full competency on the part of the patient when she changed her will. But the patients are manipulators. I love patients. Patients are great people, but they are manipulative too when there's a desired result. So to answer your question, I know I went off on a tangent. You have to be vigilant, and whomever is handling your mail, it's not this, rubber stamp perfunctory function of, okay, send it out, okay, send it out. I tell everyone, really try to avoid, and I'm not trying to spend your money, but really try to avoid mailing. Try to avoid mailing records. Try to move more towards electronically and encrypted or securely transmitting records. It's not as daunting as you think it is. It's also not as expensive as you think it is. I pay $1,200 per year. It started at $2,300, but I negotiated them down. I pay $1,200 a year to use a Citrix share file, and I get a little encrypted link, and I send these out. I can also send them directly from share file out to where I need to go. Doctors can put their records in my Citrix share file and upload them on my end. It's essentially like a Dropbox, but Dropbox is not HIPAA compliant. So I don't encourage you to go that route. Anyway, I have gone over my time. I know I've been answering questions as we go through, and one could talk about the fascinating and scintillating nooks and crannies of the HIPAA statute and all its compliance requirements for hours and hours. Bottom line for you is, when you get back, when you get back from AROC, figure out if you are compliant. When in doubt, kick it over to someone like me to make a determination for you. I certainly would be happy to do that. Here's my contact information if anyone needs it. And if anyone has any further questions, I would simply just say, drop me an email. And I welcome you also to listen to Dr. Carr's scintillating next presentation, and I'll be back at 10:30 to talk about human trafficking. What was that? Or sooner. So thank you very much for your time today. It's an honor to be here.